Thank you everyone for joining. Good afternoon. So we're going to start now, and I'm going to invite the chairman of the Nigerian Bar Association section on legal practice, Mrs. Folashade Ali, SAN, to give her welcome remarks. Mrs. Ali.
Thank you, and good afternoon, Leonard Silks. Dear panelists that have joined, I see we're over 190 at 2 minutes past. That's record breaking. Thank you all for joining. Distinguished colleagues, dear participants, ladies and gentlemen. It's indeed my pleasure to welcome everyone to this session that's been organized by the MBA Section on Legal Practice, Arbitration and ADR Committee that's been headed by Isaiah Buzimo, Senior Advocate of Nigeria, and Mrs. Adeyinka Oyewun. She is the chairman for this subcommittee on mediation, and in particular to the launch of the Mediation First, the Lawyers Playbook series. For me, this program comes at a time that's so important for our profession. Across jurisdiction and increasingly here in Nigeria, there's indeed a growing recognition that a litigation-first approach does not always serve the best interest of clients. It often leads to increased cost, delays, strained relationship, and outcome that, while legally sound, may not be commercially or practically optimal. At the same time, mediation has become firmly embedded within our dispute resolution process through court-connected systems like the LMDC, institutional mechanisms, and through our private practices. So today we're going to be looking at the effectiveness of mediation, that it does not depend only on the process, but depends significantly on us lawyers. How do we advise our clients? How early do we identify opportunities for resolution? And how do we conduct ourselves when indeed we do set up this mediation? What we're seeking to do as a section with this series is to contribute to a shift in our professional practice and our mindset from a default of escalation to a more considered, strategic, and client-centered approach to dispute resolution. And this is a broader commitment of our section on legal practice to strengthening practical competence in ADR, which I'm proud to say I'm a member of, and ensure that our members are equipped not just with knowledge, but with skills that can be applied immediately. I'm therefore particularly pleased that this program has been designed as a practical, interactive learning experience rather than a traditional lecture format. Let me lastly thank the ADR committee and all the committee and faculty members who have been carefully, I must say, selected for their expertise and knowledge in ADR. In particular, I'd like to thank my mentor, Mrs. Adedoyin Rhodes-Vival, Senior Advocate of Nigeria, Chartered Arbitrator, my friend and chairman of CRAB UK Nigerian branch, Mrs. Shola Adegbomire, my learned brother, Silkende Aino, my brother and friend, David Ogegbe, Senior Advocate of Nigeria, and to my diligent and ever hardworking ADR expert, Mr. Yemi Agbelusi, fellow of the Chartered Institute, I thank you. Last but not least, Mrs. Chinyere Onyema, I thank you for volunteering, everyone, for sharing your knowledge. And I would like to thank the able moderator, Mr. Olabisi Makonjola, a friend of SLP, for agreeing to moderate this powerful set of speakers. I feel really sorry for you. I encourage all participants to engage actively, as the value of this session will lie much in your participation and in the question and answer time. So I'd like to invite Mrs. Adeyinka Aroyewun, the chairman of the mediation subcommittee, to take us through the program and set the context for today's session. Thank you all for joining. Thank you. You're muted, ma'am. I think she's still muted.
Okay, she was not allowing, the thing wasn't allowing me to mute.
Okay.
That was why.
Okay, thank
So
you.
I want to say a very big thank you, Madam Chair. And I want to greet everybody here. Good afternoon. Thank you all for joining. So building on the remarks of the chairman, Mrs. Ali, I will briefly introduce the structure of this series and what you can expect from today's session. So before I proceed, I'd like to convey the apologies of the chair of the Arbitration and Media Committee, Isaiah Bosimo SCN, is unavoidably absent at the moment, but we hope that he will be able to join us before the close of the meeting. So the mediation first, the Lawyer's Playbook series, was developed to address a very practical gap in our day-to-day practice. So while mediation is widely available for many disputes that could be resolved early are still escalated, often because the clients are not advised early enough about mediation. Mediation is introduced late, or it is not approached in a strategic way. So, but this series is therefore designed to focus on what lawyers actually do in practice and not in theory. It is structured into two complementary editions. The edition 1, which we are holding today, it focuses on how lawyers advise clients to consider mediation early and strategically. And edition 2 will focus on how lawyers represent their clients within mediation, from opening mediation early and strategically, from opening discussions through to settlement. So today's session is deliberately designed as a practical simulation-driven workshop. We'll be working with a single course scenario, which I'm going to share after me speaking. And each session will build on that scenario to reflect real-life progression, from advising the client to assessing suitability to structuring the conversation and then addressing ethical considerations. You will notice that the format is different from a typical webinar. Sessions are tightly structured, faculty inputs are concise, and of course, significant portion of the time is dedicated to participant engagement, exercises, and role play. So we encourage you to participate actively in the chat. Please, use the chat, engage with the exercises, approach the discussions from a practical standpoint. That's what we want. What you would actually do in your own practice. That's what we want to see. That's what we want to hear, as would have been seen. And then, upon registration, of course, we will receive a set of practical take-home tools. It includes a client advisory checklist. It includes a mediation suitability decision framework and a client-facing explainer where you can, a guide that you can use facing your client and explaining why mediation first. So all these are designed to support immediate application in practice. And that's what we hope to see, that immediately after this webinar, participants will apply this, what they've learned, they will apply it in their practice. So finally, I would like to thank faculty. Mrs. Ali, our chair, has already said thank you to the faculty. I want to say thank you again for your time. Thank you for your contribution to this program. With that, I will now invite our moderator, Mr. Olabisima Konjola, who will guide us through the sessions. Thank you very much.
Thank you very much, and good afternoon, everybody. As we all know, mediation is routinely described as an alternative to litigation. Now, that framing, while technically accurate, for me, it misses the point. For practitioners who understand what mediation actually offers, it is not an alternative. It is often the preferred route. What we intend to do today is to have a bird's eye view as to why mediation. And I will not be doing this. I have a distinguished faculty that will be doing this, and permit me to spend the next few minutes introducing them. I have Mrs. Adedoyin Oyinkon Rose-Vival, Senior Advocate of Nigeria, Chartered Arbitrator, and Fellow of Institute of Directors. She is a distinguished lawyer with over 45 years experience and the founder and managing partner of Doyin Rose-Vival and Co. Legal Practitioners. She's a pioneer chairperson of the Nigerian Bar Association Session on Business Law, Committee on Arbitration and EDR, and past chairman of the Chartered Institute of Arbitrators International. She's a member of the International Chamber of Commerce Court of Arbitration, and she's the author of Commercial Arbitration Law and Practice in Nigeria. Ladies and gentlemen, Mrs. Adedoyin Rose-Vival. Up next is Mr. Kehinde Aina, SAN, OFR. He's a distinguished attorney renowned for his visionary leadership and excellence in litigation, mediation, and commercial arbitration and corporate practice. He has a first degree in political science, prior to his law degree, and has led a wide range of high-profile cases across banking, oil and gas, maritime, and corporate finance. He founded the Lagos Multi-Door Courthouse, which obviously has expanded to what it is today. Ladies and gentlemen, I welcome Mr. Kehinde Aino, Senior Advocate of Nigeria. We also have Mr. David Ogebe, Senior Advocate of Nigeria. Is a partner at Convergence Law Practice, a dynamic full-service law firm in Lagos with over 23 years experience. He specializes in complex commercial transactions, international commercial arbitration, and high-stakes dispute resolution. Mrs. Shola Adegbamire is a friend of the family. She is a legal practitioner, a chartered arbitrator, a chartered mediator, an estate planning consultant, and a trainer, an accredited mediator with the Center for Effective Resolution and a member of the panel of neutrals of the Lagos Multi-Door Courthouse. Up next is Mrs. Chinyere Onyemenem. She is a legal practitioner and alternative dispute resolution practitioner. Her career began in the banking sector and was followed by significant roles within the oil and gas sector and subsequently in real estate. She has over 10 years, which she has dedicated to mediation. She's highly recognized as a highly skilled mediator, regularly facilitating training sessions, and she holds international accreditation certifications. Last but not the least is Dr. Adeyemi Agbelusi. He is the principal partner at Beren Associates. Mr. Agbelusi is a fellow of the Chartered Institute of Advanced Legal Studies, University of London, and a fellow of the Institute of Chartered Mediators and Arbitrators. He serves as branch secretary of SIAB Nigeria and is an approved tutor. Today's session will begin with why mediation. And like I said, I'm not doing this alone. I'll be doing this with the distinguished panelists that we have here. And so I'll invite Mr. Kehinde Aino, SAN, for the next 7 minutes. Why mediation first? Why not litigation? Why not arbitration? And sometimes, why not the police station? Mr. Kehinde, SAN, you have the floor, sir.
Madam Chair and Leonard Brother Silk, Mrs. Folashade Ali, SAN, fellow panelists for this particular session. Let me begin by commending the SLP for putting this very creative gathering together, and especially for the approach and the topic which has been chosen for today, especially because of the practical bent of that session in itself. So I want to thank you also for inviting me. It's a real pleasure to be here.
Apologies. Apology. I think we have some technical issues. Let's just give Leonard Silk 1 minute. I'll try to reach out to him and I'll come back to us. Apologies, please.
Sorry, can you hear me now? I think I lost you for a minute. Sorry, can you confirm I can be heard?
Yes, please. You have the floor, Silk. Yes, please.
Okay, so I said I will start by referring to George Washington, who was the first, president of the United States, and I would like to make reference to his inaugural State of the Union address. And there is a quote in that address which I think is very apposite for what I would like to talk about. And let me quote him. He says, "To be prepared for war is one of the most effectual means of preserving peace." Let me repeat that again. To be prepared for war is one of the most effectual means of preserving peace. Now, I believe that statement from George Washington is as appropriate in geopolitics and national affairs as it is in commercial transactions, especially for us lawyers who are representing clients, so that we're able to understand what is the approach we want to take and what we want to do in terms of that representation. When I listened to the chair in her opening remarks, she made the point that the whole essence of this session is to look at a more considered and strategic approach to dispute resolution. By extension, strategic approach to representation of clients. Now, that then leads me to the topic of today itself, which is about mediation first, the playbook for lawyers. Now, the question for me in that particular statement is around the fact of, is it really mediation first? Or is it litigation first? Or is it arbitration first? The answer to that question for me is that it depends. So my inclination is to contemplate a way in which the topic may well be best suited to say mediation without necessarily saying mediation first. Because a decision as to whether it should be mediation first should be largely influenced by a whole range of factors. What do you want to achieve? What's the strategic intent of that representation for the clients? That's number one. Number two, what exactly is the client intending to achieve? What do they really want from you? Number three, is the matter itself ripe for mediation, as it were? Don't forget that mediation is really negotiations that is assisted by a third party. So it is a turbocharged negotiation. So to that end, therefore, the decision to take as to whether it is mediation first or otherwise should be dependent and be weighed very carefully in terms of the strategic approach or the legal reasoning of what you want to achieve in the grand scheme of things. So I would be inclined to think more about mediation, the lawyer's playbook series, and then allow the nature of the dispute, the relationship between the parties, and a whole wide range of factors to determine what should come first. And to that end, it may well be the case in which a matter that starts with litigation need not end with litigation. Mediation can come in the course of litigation. A matter that starts from mediation may be best suited for it to begin with mediation. But there are times when the best way to get the parties to the table and to get them to negotiate and for mediation to be meaningful may require that you actually start the process with litigation. And which is the reason why the statement by George Washington becomes very useful for us in terms of representation. You may have to prepare for that litigation in order to ensure that that mediation can be meaningful. And I think examples abound all over the world, and examples abound even in this day and age as we witness what is going on with Iran, United States, and also Israel. And I think those examples and those lessons are also useful for us in legal practice. Let me present you an example as to what I am saying in this respect. Barely a week or 2 weeks ago, I think it was, that we have an instruction to represent a former chief executive of a commercial bank in Nigeria. Let me call him Dr. A. Dr. A was disengaged from the bank maybe about 12 years ago. Upon his disengagement, of course, he wasn't happy with the manner of disengagement. He instructed his lawyers for representation. So the matter was taken to court. He began at the Federal High Court and has been in Federal High Court for the past 12 years. Recently, he approached us to discuss on this matter in order to determine what to do. When we reviewed the file and then saw exactly the way the matter was and how long it's taken, we decided to do a couple of things. First, we engaged with him in terms of the representation and the approach we intend to take. And more importantly, we also engaged with him and negotiated on our fees. Once our fees was agreed upon and what the structure of that fees was going to be, we made him understand the approach we're going to take. And it was in 3 different buckets. Bucket 1, we would engage with the lawyer that was representing him to let him know that we're taking on the representation, and he happens to be a law firm I know very well. And then we decided that the matter will be taken from the Federal High Court into the National Industrial Court, because it's to a large extent an employee-employer kind of scenario as relates to the dispute. It was a classical, First Bank against Longe kind of scenario, but the facts are a little bit different, but it's along those lines. So we said we'll engage with them and then transfer the matter to the National Industrial Court. That's number 1, part 1. Part 2, we would engage with the bank itself directly and begin to engage in terms of how we can resolve the matter and how the parties can negotiate. And we made him understand that we'll go on this route simultaneously. Thirdly, as well, we'll try and find a way to get the central bank to be involved in the matter, because I am not prepared to spend another 12 years in litigating this matter. But we will begin with litigation. In other words, we'll amend the processes, have the matters transferred from the Federal High Court to the National Industrial Court, and then amend the processes accordingly. Then we are fully suited and prepared in terms of that representation. Once that is done, the engagement with the bank would also begin. And then once we're able to do that, then we're able to then see how that common ground can be realized. That, in my view, is one clear-cut example as it relates to strategic representation. Don't forget, the issue of my fees, whether it is through litigation or whether it is through mediation, is already assured. What am I then doing? I am starting with litigation. I am going to kick in negotiation in the course of that. So I'm going to kick in mediation. What do I have? I have what I'll call a lead litigation, negotiation, and then mediation if necessary. So if I was to then flip the coin and say, let me go to mediation first, the reality is that there's no guarantee that the parties will listen and they'll be able to find that common ground. What do I think the law firm that represented them originally did wrong? I do believe that given the nature of the case, they should have contemplated mediation at the first level and then see exactly whether the parties can sit down at the table and find that solution to the problem before proceeding to a full-blown litigation that has not gotten stopped for about 12 years. And I think, like the chair said, is to be very, very strategic to ensure that a depth of legal reasoning comes on board in terms of today's representation. And that, I think, is what legal representation requires, and the clients today do need and do require of the lawyers that are representing them. Otherwise, they will leave you and go to somewhere else. So thank you very much, moderator. It's a pleasure indeed, and I thank you again for the opportunity. Thank you.
Thank you very much, Leonard Silk. I like what you talk about. You talk about strategic representation. I hear that sometimes you may start with litigation, but ultimately have your eye on mediation and end at mediation. And that is not every time that you must indeed start with litigation. You could start with mediation, end at litigation, or vice versa. I like also what you say when you say that mediation is negotiation assisted by a third party. Now, what I wanted to say at the beginning of this session is that today's event is going to be in 4 parts. So part 1 will be why mediation first. And so we've listened to Mr. Kende Ainoese and shares perspective on why mediation first. The next speaker on why mediation first will be Mrs. Adedoyin Rose-Vivo. And thereafter, we'll go to Mr. David Ogebe, who will then take us through the scenario drill. When we registered, we got the pack, and I urge us all to read that Mr. Ogebe will be taking us through a simulation of that fact pattern that was shared with us. And so I'll use the floor now to Mrs. Adedoyin Rosevivo SAN to share her perspectives on why mediation, litigation first versus client interest. Bennett Silk, you have the floor, ma'am.
Okay, good afternoon. The chair of the session, Madam Silk Folashade Ali, chairman of the committee, all my distinguished colleagues, and the various participants. Thank you for having me here. I think I want to start first by the query that Mr. Kende, I know, put to the floor, that why mediation first, that he would have preferred mediation without the first. And I think I tend to agree along these lines of reason, because it's all strategic. For instance, if you go to litigation first, it also assists. In some cases, not all cases, as you mentioned, you have to think of whether which is ideal in that particular situation. There are some times that a client has to be aware of the weakness of his case. And by the time he sees those pleadings, seeing the weakness of his case, most likely his lawyers have said, I need this document, I need that document. And he doesn't have that. And he tells his client XYZ. And the lawyer says, but this is just on paper. Where's the evidence? He may begin to think it through. But having filed the litigation and having seen the weaknesses of his case, his or her case or company's case, he may then decide that it's best to go to mediation at that stage. But then we can see that in that case it wasn't mediation first, it was litigation. So it really depends. It's not a rule that's cast in stone. Lawyers have to be strategic and look at the wholesomeness of the case and then put their opinions or their advice to the client. And then aside from that, I just wanted to mention that in support of Mr. Kende, I know SAN. I also want to mention that you see, mediation is a voluntary process. And a lot depends on the way we lawyers conduct ourselves and the way we perceive our responsibilities. I think it's important for lawyers to realize it's not their duty just to look at it in terms of money. It's not their duty. They should be client-centric, as the president of the ICC says. She coined that phrase. And I think the chairman of the section also mentioned it, Mrs. Folashade Ali, SAN. You have to be client-centric. You have to be aware of your duties as a lawyer. We should be aware of the provisions of the Legal Practitioners Act, which refers to the responsibility of lawyers. It reminds us that we are to assist the courts in the administration of justice. By clogging the court's docket with cases that could have easily settled, cases that are best suited for mediation, we are not assisting in the administration of justice. When we also look at the rules of professional conduct at the bar, the kind of conduct we are supposed to reflect our responsibility upholding the honor, integrity, and reputation of the profession also illustrates the fact that we should not always look at cases that are referred to us in terms of money, but in terms of what is best for the client, what is best in the interest of the courts, and our judges who are always overburdened with cases, various cases that don't have to come to court. You have some cases, a tenant, he's owing money for about 5 years, he has not paid. Then he brings all kinds of unnecessary allegations against the landlord. Very recently I had a case like that. This case had been on for a couple of years, and the client got in touch with me and said that this tenant was refusing to vacate his property, a high-rise luxury block of flats, that the tenant claims that he had collected, I think this was about maybe 10 years, he had collected maybe $5,000, and that he didn't provide a lift, he didn't provide a number of things. So I told to my client, I said, come, do you know how much a flat in a luxury building in, I think the building was somewhere in this estate, near Oniru. I said, do you know how much a flat goes for there now? I said, so you have kept yourself in court for the past so and so number of years because this tenant says you didn't provide lift, you did not provide this, you didn't provide that. I said, it's best you settle this amicably and go and get rent for this building. And in this case, I was lucky. The lawyer on the other side was also a sensible person. So I called that lawyer. I said, you know something? even if you win this case, what are you claiming for? You are claiming for the fact that he didn't install lift, he didn't install elevator, he didn't do this, he didn't do that. I said, at the same time, you have kept this man out of his property for the past 5 years. So even if you are awarded that in damages, you are going to pay your rent. You are going to pay your rent. And the rent, that value of that property is much higher than these claims you are making against him. Anyway, eventually, it didn't even take time. My client listened to me. The lawyer on the other side was sensible. The matter was settled. And after 5 or 6 years of being kept out of his property, a high-rise flat, a high-rise luxury property, he got his property back. And they were very grateful to me. So that shows the ability to be able to look at the client's interest. I could have gone along with the other lawyers in the case and said we are filed. There were so many cases that didn't filed in court. But I advised them against it. You go and get your property back. You, even if you win your case of this was not provided, that was not provided, you are still going to have to pay your rent for illegally holding on to that property. You have to pay the main profits. So that's why I think it's important in occasions such as this, always remind our colleagues of what their duty is. Their duty is not merely making money. And then even if we look at the various relevant laws, the High Court of Lagos State Civil Procedure Rules, it talks about the fact that before the commencement of proceedings, all avenues for amicable settlement, including ADR, should have been explored. If you go to the Federal High Court Civil Procedure Rules, Order 18 Rule 1, where a matter comes before the court for the first time, the judge shall, in circumstances where it's appropriate, grant to the parties time not more than 30 days within which parties may explore possibilities for settlement of the dispute. We have the same similar provision in the High Court rules of the Federal Capital Territory, and even in the National and Industrial Court rules. In any civil proceedings before the court, it shall be the primary duty of the court after the parties have joined issues, and this talks about after the parties have joined issues, to give a clearer viewpoint of what the dispute is about, what the evidence on each side is. The court has said the judge has a primary duty to promote reconciliation, encourage as well as facilitate amicable settlement of disputes among the parties. In fact, right even before the era of the multi-door courthouses, it's always been a provision in high court laws that the court has a duty to promote reconciliation. And I think many lawyers seem to be forgetting that point. I think lawyers have to go back to what motivates them as a person. What is their motivating factor as a lawyer? Is it to be a crucial part of the law of law, to assist law to grow, to assist the courts, or is it merely to make money? That shouldn't be the case. A lawyer has to consider what their professional obligations is, what their duty is to the clients. Am I going to be client-centric, or money will be my chief consideration? I don't think that should be the case. So let us all go back to our rules of professional conduct, particularly the younger lawyers, which I think many of them might be on this program. Let's go back to our rules of professional conduct. You can still make your money, decent money, by advising your clients appropriately, letting them know the options, letting them know that it's not always the best thing to keep a case in court for the next 5, 10, 15 years, and to keep paying lawyers. I've had even arbitration proceedings, international arbitration proceedings, where I've advised my clients, settle this matter. And I tell them up front. I mean, if I don't tell them, I guess they'll keep me there as a lawyer. I'll keep on earning my fees on hourly basis. But I tell them arbitration is expensive, particularly international arbitration. And if you keep this matter in court, in the arbitration, you are going to keep on paying the institution, you are going to pay your lawyers, and it's not even in Naira. So I think all lawyers should have that spirit and that viewpoint to think of what is in the best interest of their client. And I'm happy to say that in many cases, in fact, even a recent one I just done, the parties settled. The parties settled. Why should I take joy in making my clients pay money that could best be invested in their business? And then another thing we have to consider is the fact that arbitration also offers, well, not arbitration, I keep saying arbitration, I'm sorry, that mediation also offers many opportunities. You know, when you are in court, most times it's the lawyer that will even draft your statement of claim, your statement of defense. So you're an invisible face. They'll draft it for you, they'll hear your story. You are not, that emotional involvement is not there. It's only when you get to court that you can begin to talk and all whatnot. But when you have mediation, there's opportunity for you to talk, opportunity for the parties to meet, opportunity to express their feelings. Most times when we have quarrels, even amongst family members, you don't even really know what the other party's viewpoint is. You didn't know that when you were a child. I know of some cases where people have complained that, well, ever since we were young, mommy preferred you, daddy preferred you. So what is their real problem is not the issue in dispute. It's not the property they're fighting over. It's really their perception of their parents' preferential treatment. You can't do anything about that in court. But when you meet one-on-one in mediation atmosphere, an experienced mediator knows how to bring the real issues in dispute between the parties to the fore, and then reconciliation can start. And that's one of the reasons why it's best to go for an amicable form of dispute resolution rather than tying yourselves up in the court system. Thank you. I hope I've not spoken for longer than I'm supposed to.
Not yet.
Not yet.
Well, thank you very much. You spoke about putting the best interest of the client first. You also say that in mediation, opportunities are plenty. There have been questions in the group. So, I mean, these are for now, they are rhetorical questions. Please don't answer them. We'll come back to answer them. We talk about opportunities for the client. What about the lawyer himself? If this matter does not go to court, how does it become a silk? Given the requirement to become a silk. If I have a good case, why should I go to mediation? What happens to my evidence? Let's keep those answers for now. Let's jump to the case study that we have, because we must do this case study, because some of these questions may come up again during this case study. Before I invite Mr. Ogebe to take us through this case study, I've seen comments where people say that they've not seen the pack. Can admin quickly share or just even if it's the first page of the case study before I invite Mr. Ogebe? Yes. So I'll just read quickly because we have to finish this session in the next 20 minutes. Okay. So Data Build Limited is a mid-sized construction and infrastructure company operating across 3 Nigerian states. Prime Cell Engineering is a specialist engineering subcontractor that has worked with Data Build for over 5 years on multiple projects. The relationship between both companies has historically been collaborative, with informal communication between the 2 MDs. Data Build awarded Prime a 4.8 billion subcontract for mechanical systems on a government hospital development project. Issues have arisen. Prime alleges late payments and scope creep. Data Build alleges delay, underperformance, and defective installation. Government inspectors have raised compliance concerns. Media scrutiny is increasing, and the hospital commissioning date is imminent. Prime claims 70 million naira in unpaid invoices and variation costs. Data Build disputes 420 million of that figure and alleges 250 million in delay-related losses. Both companies have reputational exposures. Both MDs have taken these disputes personally, as we do in Nigeria today. Nobody's green for anybody, as they see on the streets. Now, despite this, both parties recognize that they're likely to work together on future public contracts, and that litigation could attract negative publicity. Arbitration would obviously delay hospital completion, and the 2 lawyers need this case to go to trial so they can submit it for SAN. Mr. Ogebe, please, you have the floor, sir. Can you take us through what mediation has to do with this case study and how this should be resolved?
Thank you very much, Mr. Makujola.
Yes, sir.
Adopt very respectful solicitations. I know. Yes, let's dive in straight away. Colleagues on the line. Please, can we go to our typing keyboards? Expect your responses, your answers to be sent through chats. As earlier stated, this is going to be interactive participate. So we want your responses as we go ahead. So all my litigation-centric lawyers here, you know that phone call that all of us praise for when we go to work in the morning is that call that the MD is angry. He wants to sue now. He wants to deal with them. You know, that's our prayer. That's the call we want. So the answer to you now is, the question to you now is, when you receive that call that will make you dance, what is your immediate response to this scenario? So this scenario is a fresh scenario. It's not like the one that was existing prior to in the case situation given by Mr. Aino, Senior Advocate of Nigeria. So this is a fresh scenario. The MD of Delta Build is upset. He feels hurt. He feels that he will be looking weak if he takes no action, and he wants to sue immediately. So in the first 5 minutes, what it would be your response? What would be your advice to the managing director? Yes, so well, looking, so I'll be responding, taking the immediate answers, the fastest answers, so that we can continue this discussion. So now we know that Delta Build already is looking at 250 million in damages. Of course, as a lawyer, you're thinking, wow, 25 million, oh, that's my cut. So what would you advise? You'll be advising in the litigation first scenario, what would be your advice? So far, I've not seen any charts there. What would be your advice to the managing director of Delta Build, who has had a working relationship, a collaborative working relationship with PrimeServe over the years? This is a pressure-filled transaction for which has a lifespan, and there is public interest because it's the revamping of a hospital. Now we're asking for advice based on litigation first. So tell us the truth, litigation lawyers. Someone here has said mediation first. No, I'm a litigation lawyer. I certainly will not say mediation first. So truthfully, if you're advising based on litigation first, based on litigation first, what would be your advice? Remember, want to recover 250 million. Your client is angry. He wants to sue immediately. Everyone is saying mediation first, mediation would advise mediation. Well, in a litigation first scenario, what would advise from my own point of view would be, so we need to file speedily. We need to good. Okay, well, there's one suggestion here, a court case to be filed ab initio where preliminary talks have failed between the parties, then mediation will be suggested. So someone says we can institute an action and simultaneously explore mediation. Okay, thank you very much. I think the kind of lawyers we have on the call are the type that have been working in Olanu Ajayi, very gentle and practical and all of that. Let me talk for the Igboshiri lawyers, we that started on Igboshiri. When you receive that call, the first thing you're going to tell to the MD is, Oga, we need to deal with this guy. We need to file an action immediately and seek Mareva applications to freeze the account of PrimeServe so that he doesn't spend the money in his custody. That is the kind of advice we'll be giving. So we have to move quickly. We have to move quickly. We have to teach him a lesson. PrimeServe has to know who the boss is. PrimeServe has to know who is in charge. So we're going to advise, let's file immediately. After we've frozen all his assets, we're frozen his funds, he'll be weak, and then he'll come to us. That is the kind of first advice that a litigation first advice would be. That's the very kind of advice that naturally would come. Now, I would ask, perhaps this will help us a little bit. From the instruction, as it were, the discussion with Mr. Okoye, what do we think Mr. Okoye actually wants right now? Maybe this can guide us. Based on the statement that Mr. Okoye made to his lawyer, and I'll repeat it. A visibly angry Mr. Okoye tells counsel, PrimeServe has embarrassed us. I want to file immediately. We cannot look weak in front of government. So he believes litigation will show strength. So having listened to what Mr. Okoye said, what do we think are the things he actually wants to get from the law, from filing the action in court? So I'm expecting your interventions in the chat. I've seen someone say, in order to preserve their business relationship, I'll recommend that a letter of demand be served to prime serve, and thereafter propose for negotiation for mediation. Yes, someone has said, I will file and freeze the account first. Thank you, Catherine. You are a negotiable lawyer like me. Thank you very much. I will file and freeze the account first. Another comment here, explore litigation first and then explore mediation while litigation is ongoing. Thank you, you're one of us. Chukwasi and since government has raised compliance issues, it may be necessary to institute litigation. Thank you. So, nice response. The MD will feel heard and understood. Thank you. Okay, what does he want? He wants to be respected. That's what I hear someone say. That's correct. He wants to be respected. He wants to maintain the integrity and goodwill of the company. Yes. Accession of power. Litigation will put the other person down. Thank you very much. That's correct. He wants payment. Well, from the comment there, from his question, it didn't appear as if payment was the main focus of what he wanted. So it would appear he was more interested in protecting his integrity. He wanted to teach the other side a lesson. So we're talking about reputation protection. We're talking about, perception. He was trying to manage perception. Yes, someone said Mr. Okoye wants an action filed immediately so that the company can look tough. Yes, that's correct. To ensure the money isn't moved, file and freeze, then call for dialogue. Correct. Thank you very much. Yes, so these are the things he wanted. He wanted to control the narrative. He wanted emotional vindication. He wanted favorable political optics with the government. So these are, from what he said, you could see that those are the motivating factors for him wanting to file the suit immediately. Now, the next question I'd like to ask is, what is the real cost of public litigation in this case? In this case with Delta Build, assuming he rushes to file the action immediately, freeze the account, and do all of that, what is the real cost of that litigation? Let's remember, there has been a collaborative working relationship between both companies. There are actually some jobs that are still ongoing, separate from this one that the dispute has arisen over. And then there's a possibility of more work to be done. Good. Someone has said the cost of this, one of the costs of this litigation is there will be a ruptured relationship. That's correct. There will be a delay in the project. Yes, there will be a delay in the project. And that's one of the key things. Someone says everything stalls, nothing moves, time is lost, materials and labor is wasted. Excellent. And that's the truth of the matter. Just because of emotions, just because of perceptions, just because of showing strength, the job is stalled. It doesn't get done. Productivity is going to be affected. Thank you very much. Relationships are damaged. The company you have been working with collaboratively for years, for 5 years, you have been doing well. If you have been doing well for 5 years, then there must have been a little breakdown that will be causing this one not to go well, which should be looked into through mediation. Yes. Again, you will see that there will now be immediate media attention and intensified government scrutiny. As a result of that, everyone will be looking at the project. The government will be looking at it. The public will be looking at it. The newspapers will carry it, So unnecessary attraction of intensified scrutiny into the project. Yes, someone has said increased cost of completion of the contract. That's very correct. The prices will soar. And then someone says it might affect him emotionally, seeing the case moving forward as he wants. Unnecessary media attention, correct. That is just a summary of all I've been saying. So these are the costs of public litigation. Of course, we're talking about the cost involved in public litigation, cost of paying counsel, the cost of filing the action in court, all those kinds of expenses. And of course, there is no guarantee of the outcome of the litigation. And then the long delay, you don't know when that litigation is going to end. So these are some of the costs of litigation. Now, what would you do differently? What would you do differently? So now we walk back to that phone call. And he says,
you have 2 minutes more, sir. Apologies.
Thank you.
2 minutes more.
All right, thank you. We walk back. You now have that phone call. I want to sue now. I am very angry. I need to show strength. I need to crush this guy. So how would you advise differently? 2 minutes, 2 minutes. How will you advise differently this time around? So we're no longer thinking like the Igboshiri lawyer that we were. Let's now think like, my advice is that reports of ADR should be considered. Oh no, that's different. How will we advise differently so that we don't go down the route of litigation first? What will we do differently? Everyone seems to be more concerned with getting silk today. Because all the comments are talking about using ADR cases for silk application. Can we come back to the focus, which is on this scenario? Anyway, in such a scenario, when the MD calls, we as counsel, need to be able to, we're not just mere instruction takers. We're not mere instruction takers. We have a duty to be solution providers. Solution providers. So we'll need to advise our client to take a step back, tell your client, so let's look at the documents, let's review it, and then we'll advise you accordingly, because at that point, he's very emotional, he's very upset. You might want to calm him down and come back to him after he has thought about it a little, and then you guide and say, look, this will happen, this will happen. The most important thing is to get the contract on time, to get the job done, and to make sure that it's done seamlessly. So that would be my reaction.
Thank you. Thank you. Thank you, Leonard Silk. One thing that is critical from what we've just done now is that litigation may, I'm trying to choose my words carefully, that's my understanding of what we've seen here. Litigation may solve it temporarily, but permanently it may not be the solution. And thank you, Lenesi, for that intervention. I'll just quickly give Lenesi, Mr. Aino and Mrs. Roosevelt just one minute. Any last words on this topic before we jump into the session 2? Just one minute, please. Mr. Kendi, I know, sir, 1 minute, sir, if you're still there.
Sorry, could you repeat that question again?
Yes, just 1 minute to just, recap on litigation first vis-a-vis mediation. Just 1 minute, just to recap.
I honestly still believe in what I said in my opening, that I don't think there is anything like mediation first, litigation first, arbitration first, or violence first. I mean, it all depends to a large extent. It depends on what is the nature of the case, what is, like the chair said, what is the strategic intent of this particular case? What do I want out of it? Bottom line is, if I'm trying to seek for silk and I have to abide by the 25-4 rule, the entire concept of mediation first does not arise. I will pursue litigation until I can get what I want.
Thank you.
To understand that. With that said, the nature of the case itself and what is all about will determine what is best for the client. And there is not a point in which it starts with litigation. It does not need to end with litigation. Mediation can come in or all the rest of it. So it depends. We have to be very strategic and see the entire universe of the dispute resolution ecosystem as options that can be pursued. Thank you.
Thank you. Thank you very much. Mrs. Roosevelt, your parting words on this topic?
I think my parting words will try to address the issue of those who are concerned that how do they get silk. It's a very interesting question, but I think if they take it in the way I took my life, it might help them a bit. Because in life, for me, you never know where life is going to take you to. And there's always the God factor. Even if you, in a very undermining manner or in a way that's not appropriate, you start encouraging your clients to go to court, where you know very well that case is not a case that should go to court. You are doing your client a disservice and you are doing yourself a disservice. At the end of the day, you may not get that silk, but you'll have ruined your reputation because nobody really thinks you have much of integrity. So I think people should look at it in that way, that not everybody is meant to be silk. And this is not saying I'm discouraging anybody. I didn't start off my career that I must be silk. In fact, I started off my career by saying that I want to work in a bank. Maybe that was when I was much more childish than this. And I felt that, oh, all the bank people, they're so, you know how bankers used to be in those days now. But I didn't get into a bank. And I went to the Ministry of Justice. And today, I thank my God every time that I started my career in the Ministry of Justice, because it gave me a very good broad spectrum experience. I even first started learning about arbitration while I was in the Ministry of Justice. And when I came out, I went to corporate practice. I had a mixed type of background. I was in ministry, then I was invited to set up the legal department of a company that was mainly Lagos State government owned. After that, and I could always do my job in the way I should do it. I was never afraid that if I don't do what a director tells me to do, I'll lose my job. Because we've got to have confidence in this world. When it was time, I moved on from there and I set up my legal practice. And I was focusing on various things. And along the way, I was getting my cases. Along the way, I was getting experience in arbitration and ADR, and I'm happy today. So please, let's not focus on, I must get SAN. Because you don't know whether God even has something greater than SAN for you. I discovered that in my life early, and I'm happy I started off being an ADR practitioner. And because I'd had the experience of being in the Ministry of Justice when I was going to court every day, I was attached to a court. I also had that rounded experience. So please, let's always remember the God factor. And don't be afraid that you won't get SAN. You won't get SAN, and so you must tell your clients to always go to court.
Thank you very much.
Moderator, I'd like to weigh in on that. Permit me to weigh in on that, please.
Please, you have 1 minute. I want to come to Mr. Gabriel next.
I, with all due respect to my learned brother Silk, Mrs. Roosevelt Essien, I'm not so sure that particular leaning would actually resonate very well with a number of people. I honestly do believe that the time has come when the entire Nigerian Bar Association should make a case as to how mediation, arbitration, and those alternatives can be part of the criteria to be considered for sale. If we truly want to decongest the courts, I think it's important for the legal community to actually make a case for it, because it is nothing other than a portrait in self-contradiction. If we have within the rules of the court that parties should settle as much as they can settle, and that settlement initiative is not being accorded the respect and the recognition it needs in terms of making silk. If I'm required to put in 20 cases on the trial side for myself, that's what I will be pursuing at the end of the day. Now, so I think we need to find a way to ensure that we can lead a crusade in order for recognition to be made in that regard. I'm aware some efforts are going on. I'm aware that the Supreme Court Mediation Center is planning to open up in no distant future. And I do hope and pray that that really will be given some consideration. And I think the appeal court and the trial court should do the same thing at the end of the day. So that will be my take on that. And I think the time has come to do something.
I'm sure the stakeholders are listening and they've taken notes. Mr. David Ogebe, your last words before we jump into session 2.
I got involved in a case where both parties had somehow conspired and gotten a vessel arrested in my client's jetty. And the vessel had been there for 5 or 6 years. Okay. I was the counsel to the jetty owner. The two partners locked it down for 5, 6 years. and the vessel was deteriorating. My client said, please get this thing out of it. I had to file papers in court and come and say, guys, what's happening? This is a very valuable asset. Why are you wasting? Why is it wasting away? And the parties were arguing, lawyers were taking sides with them. Anyway, I brought application and said, my lord, let us even go and see the vessel. The counsel to the party that arrested it, who was being difficult, I said, please bring your client. We are all in our AC offices, enjoying yourself, and this asset is dying. Let's go there and let's see it. And his client came, we all went there. And the client of the client that arrested the vessel, when we got on the vessel, he wept like a baby. He wept like a baby simply because of pride, emotions, and unfortunately for counsel who could not guide to say, look, what commercially it makes no sense. So a vessel is equipment that was valued over $12 million. Eventually it sunk. Everybody lost. The council lost. Nobody gained from that. Please, mediation makes a lot of sense. And like Mrs. Rosvivo said earlier, it takes two. So if all of us lawyers have that mindset that, look, before we go to war, while we have even set up our structures for war, can we settle commercially? Would it pay everyone better? Let's have that mindset. It's not everything that has to be violence. I'll win by all means. Thank you.
Thank you, Lenny Silk. I hear you very well, loud and clear. And I think it's a clarion call for all of us lawyers not to put our interests first, but to put our respective clients' commercial interests first. On that note, we'll quickly jump into session 2. Session 2, it's on identifying suitable cases for mediation. And the faculty will be led by Mrs. Olushola Adegbomire, a seasoned mediator. Now, we remember the data build disputes that we ran through a while ago. I'll just ask, that we in the chat box just, put there whether we think that dispute is one that can be resolved through mediation quickly. And then I'll invite Mrs. Olushola Adegbomire to take us through case screening as relates to identifying cases suitable for mediation. Mrs. Adegbomire, you have the floor, but please keep the chat going on whether you think that this dispute is one that should be mediated. The dispute between data build and prime serve. Mrs. Adegbomire, you have the floor, ma'am. Admin, please, can you give access to Mrs. Adegbomire?
Yeah.
Okay, thank you very much. Thank you for the privilege to speak here. And then we'll be taking section 2, which deals with case screening. Please, I hope you can hear me.
Yes, please. Yes, please, we can.
Thank you. Okay, so what is case screening? Case screening is basically about deciding which case is good for mediation or which case is not good for mediation. I have enjoyed what has been said before me, about mediation first. I also believe in mediation first to a certain extent. I also believe in mediation first to a certain extent. And there are some jurisdictions where the corporate commercial people in that jurisdiction have all agreed, signed to sort of a pledge. At least many of them have signed to a pledge that before we do anything, we'll mediate first. But this is a group of corporate commercial people, and it's been working for them. And it will continue most likely, because it will first of all reduce the dockets of judges and allow them time for cases that cannot be mediated. Of course,
There are many cases that cannot be mediated. It's not every case that can be mediated. And so in this session, we have to look at what cases are suitable. How do we determine? That's why we call it case screening. How do we determine which cases are good for mediation, which cases are appropriate for mediation? And even sometimes after we have started litigation, we must be able to sit down at some point and say, maybe we should shift or maybe we should change our strategy to mediation. And so that's what we want to look at, you know. So case screening, it starts with the lawyer. Oftentimes, I've had to advise clients that, look, I think this case will be better, we go to mediation. Sometimes some people don't want to do that because they feel, in fact, let me say one thing that I've heard some people describe ADR as. Mediation is part of ADR. And when this term for ADR was used, it was used in connection with mediation. In fact, I first heard it from Mrs. Aroyeun, that some lawyers decided that ADR means accelerated drop in revenue. Alarming drop in revenue. That Mr. Aroyeun, you remember, alarming drop in revenue. Why did they consider it an alarming drop in revenue? That if you go to mediation, especially, you help your parties, your clients, you help your client settle his case quickly, it reduces your revenue because they're thinking, if we're in court for the next 5 years, 6 years, 10 years, especially those who even charge by the, I think, appearance fees and things like that, we'll continue to make money from this client for a very long time. So why should we help him solve his problem by going to mediation? It's an alarming drop in revenue, you know. So unfortunately, some people still think like that. And it always reminds me of this photo frame. It was a picture that in the old days, you saw it in so many offices. These days, I don't see it as often. I think maybe lawyers are wiser. But for those of you, I don't know how many of you have seen the picture of the big fat cow. And that cow, in some cases, has 2 heads, in some cases, a head and a tail. But on each side, one person is pulling. The claimant is pulling on one side, the respondent is pulling on the other side, and the lawyer is sitting down in his wig and gown under the cow, quietly milking the cow. So he leaves them to fight for as long as possible because he believes that he makes more money for as long as they are fighting. And I know that there may be 1 or 2 people here on this platform this afternoon who probably still feel, why should we help them settle by mediation? Wouldn't it better they just keep fighting? But I assure you that it's better, because for me, I think that you still charge a fee. Like, I'm happy Mr. Kende told us about how in a particular case, the first thing he advised the client, he told him how much he will charge for mediation. So, and you resolve it faster, so you get your money quicker. But how do we then identify? And so it must start, case screening must start from the lawyer's office. One thing I used to do for a lot of people say, no, we must fight to the end. I have a few cases that we have done in time past. Some of them are about, I don't know if you can see my hands. Some of them are, in fact, now, so they're not this, they're not this, they're not this. You can't even see my hands again. They're that fat. You have about 4 or 5 files, each one very thick of litigation on one single case. So sometimes when I have those very difficult clients who feel that the only way is by litigation, and I'm looking at a case that we can settle this by mediation, and sometimes I go and bring out, I say, look at this file. This is one single file for one single case. If you know how long we have been at it, then sometimes they will now calm down. I said, do you want us to go through the same for you? Especially when I've been able to see it. Many times, I think case screening, it will start from the lawyer. Many times the clients, even for the simplest cases, the clients are angry. They're angry with the other party. They are feeling cheated. They are feeling oppressed. They are feeling one way or the other, that they are not even seeing. They come to you not because they can see mediation. They come to you because they see a fighter. Somebody will fight for them. So, but how do we identify what is suitable for mediation and pass it on to them? That's what we want to look at. There are many cases that come before us that are suitable. Like I say, and I know that Mr. Kehinde, I know, has said it. It is not every case, no, that is suitable for mediation. But the ones that are suitable, how do we identify them? How? That's what we want to look at. The indicators for cases that are suitable. First of all, from the lawyer's point of view, how do we identify? And let's start with looking at our prime serve, delta build, and prime serve case. It's a good one to look at to say, is this case suitable for mediation or not? Should we try mediation first before we now go to litigation or arbitration? And that's why we even we encourage, even in mediation, for arbitration practitioners, we now encourage, and it's a best practice, especially in commercial law. When we have commercial contracts, we have what we call a multi-tiered dispute resolution clause. A dispute resolution clause which says, in case there's a dispute, we will try mediation first. If mediation does not succeed, then we'll go to arbitration. And to make mediation even more encouraging globally and global best practice, these days, in many of the international institutions for arbitration, they are now even encouraging what is called mediation during arbitration. So the Charter Institute of Arbitrators has a guideline on mediation during arbitration. The ICC has the guideline on it, just to show you where we are all going with regards to mediation. So start your dispute with mediation first, with a multi-tiered dispute resolution clause that says mediation first. And then you can go to arbitration. And while you're in arbitration, you can still go back to mediation. But how do we determine which one should come first, or what are the indicators for which ones we can take, which ones will take mediation, or which ones we cannot take mediation? So the case screening. One of the first things you need to look at, because such cases you may not be able to do mediation, is there a need for judicial determination? Now, let's ask that question in the Delta Build case. Let's look at our Delta Build case, and let's also talk together. So, in some cases, you need judicial determination, criminal matters, matrimonial, as in to determine that this marriage is dissolved. You need proper judicial intervention. Sometimes you need an urgent relief. This house must not be pulled down. The mediator cannot do that for you. When you see that they're already going tomorrow to go and pull down the house, the mediator cannot stop them. The mediator does not have anything, and the other side is not going to agree with you because they're the ones who want to pull it down. He doesn't have any police of his own to stop it. So those are things that we need to look at. But let us look. I know that Mr. Ogebe has talked about some of these things with regard to our Delta Build case. But let's look at our Delta Build case. And let's look at what are the things we would consider if we
Just to add, Mr. Adigbomire, that majority of the respondents here agree that this Delta Build case is one that ought to be resolved by mediation. So
yes,
I think
that's what I said. Mr. Ogebe had already talked about it. So maybe we'll just look at other cases and just ask ourselves, let's look at a matrimonial case, for example. What are the things you will think about when you have a matrimonial matter, husband and wife? But husband and wife are fighting to death. They have 2 children. Each one is asking for sole custody of the children. Each one wants the house that they built. Many things that they are fighting on. Let me ask you, what will you look at? How will you advise the client? There's a matrimonial matter, but there are other things they're fighting about. I can't find the chat box here because I want to ask you those questions. How do you, let me ask my technical people. Please come and help me look for I can't find the chat box has
I'm following the chat here.
Okay, so tell me. So you have
let you know.
A couple, husband and wife, they want to kill themselves. I'm looking for it here as well. They want to kill themselves. And okay, we found it. But then there are other issues in the matter, many other issues in the matter. What would you suggest to your clients? Should they just go to court and fight out everything and also spill the beans? Because the husband is accusing the wife of certain things that are unspeakable. The wife is also accusing the husband of unspeakable things.
There's
I
a
had
comment
a case
from
where
Abiola Abiodun that says that they can settle it using mediation to settle the issues that do not require judicial determination. Children are priority. Property should be sold and shared in proportion. That's another comment. As they come out, I put them out.
Well, property should be sold and shared. Nobody wants to. In fact, we have one ongoing. Both of them want the property. One says, okay, I will give you a share. The other says, no, I will buy you out. What is the best thing for them to do? They can wait for the courts to determine. If somebody says, let's go to court, but I like the first one. Mrs. Abiola Abiodun, who I know is a seasoned mediator herself, so I can understand her saying mediation will be faster and in Kolika, mediation will be faster and helps to protect the integrity of the family. Do mediation of the issues that do not require judicial determination, which means that we can decide that there are some of these issues. So even where you can only go to court, it's only the courts that can determine the marriage. Sometimes we find issues within it that will require mediation. And we can encourage our clients on such matters, because I've seen some, they will just refuse to want to talk. But the best is, looking at that, it is clear that if we screen very well, we can advise the client that, look, let us not go and wash our dirty linen in public. Let us sit down and mediate these issues that we are fighting about with your spouse, and then we just go to court just for them to knock the nails in the coffin of the marriage. But the real issues we can decide in mediation. Sometimes another one I saw, which I found very...
Just to note that you have 2 minutes more. Just 2 minutes.
Maybe a scandal dispute. Somebody is suing the other. You scandalize me. What would you advise? Would you advise that we go to court? Sometimes you have to look at, is there room for compromise? Is there room for flexibility? Are the parties willing to talk? If the parties are willing to talk, then let's go on. Let's sit down and talk. When they're not willing to talk, when they're not willing to even hear each other, of course, we have to go to litigation. But I always believe it is the duty of the client, it is the duty, of the counsel to advise on these things. Look, there's still room. Let us see if we can talk. Is confidentiality important? All these things Mr. Ogebe had also talked about. Relationship preservation. These are things we need to consider when we are screening the case. So, will mediation help to reduce cost? And oftentimes I've seen that mediation reduces cost, it reduces delay. In fact, the LMDC have what they call a time-bound mediation, that within 3 hours, you can actually settle your matter in 3 hours. But these are the things we need to consider when we are thinking of, should we or should we not? And it always starts with the lawyer. It never starts with the client. It's very rare that the client comes to you asking for mediation. It is often that the client comes to you to fight. You will then look at all these things, the relationship, the cost, the time, and then we will advise the clients that in the light of all these things, rather than go to court to go and waste time, to go and embarrass yourself, to go and spend so much money, why don't you consider mediation? And I think when we do that, and lawyers have a duty, it's a duty we have. It's not something that we just do or we don't do. It's a duty we have, and we'll look at that later in this session. It's a duty we have to advise our clients to consider mediation first wherever it is possible. Even in some criminal matters, I keep saying, even 419 matters, there are some cases where all the person wants, I want my money back. I've seen a criminal matter, somebody took money from another, under false pretenses. The owner of the money said, all I want is my money back. What do you want to advise your clients? Do you think you should advise to fight and make sure it goes to jail, or get your 10 million back as quickly as possible so you continue your own business? So in so many cases as lawyers, we would do that and we will still collect our fees. I'm happy that's where...
I'm afraid I have to
Yes,
stop.
I'll stop there just to
Thank
say
you.
we can do
Thank
that
you.
and we can still make money.
Thank you.
Thank you.
I like what you say. What resonates with me the most in what you said, ma'am, is that except when you need the court's judicial imprimatur, there is no case that is not, that cannot be resolved through mediation. So very, very well noted, and I'll keep that somewhere so that I don't forget it. Now, we'll jump quickly to the third session. Now, we've seen a factual pattern. We've been told about cases that cannot be mediated or cases that ought to be mediated. Now, how do we advise our clients when you've now been briefed? How do you tell your client that rather than go to court to secure an injunction, I think that I should write them a letter and say, let us mediate? Won't the client think I'm a soft lawyer and then go to a lawyer that I feels knows his onions? Mrs. Chinyere Onyemenem has the distinguished honor of taking us through this session, which is advising the client, the 5-step mediation advice framework. Mrs. Onyemenem, you have the floor, ma'am. Admin, please give access to Mrs. Onyemenem. One second, please. Just trying to check that she's here. Mrs. Onyemenem, are you there? Okay, it appears she's not online. We'll park our session and then quickly jump into session 4. Session 4 is on ethics and professional duties. I'd invite again Mrs. Adegbomire and Dr. Adeyemi Agbelusi to take us through this ethics and professional ethics. Okay, I'm told she's here, but she's muted. Mr. Yemenem, please, can you unmute her? Or you raise your hand so that the admin can identify you and unmute you.
Hello, Mr. Makonjola. Mr. Oyeme, Chinyere said she can't unmute, and
Can
that's why she's not talking.
Can she raise her hand so she's then unmuted?
Okay, can you please put on your video, Ms. Oyeme, and put on your video and, and raise your hand. Let's see you.
Yeah, I've unmuted her now. I think she can speak now. Yes, she.
Thank you. Sorry.
Sorry, apologies.
Yeah, that happens. Thank you so much. I want to give my respect to the SANs we have in the house, the chairman of the section, all those who have spoken before me, and those who are here present. If you would just permit me, I'm trying to share my screen. I hope I can, and it's just one slide. It won't take time. I would like to speak to it, and then let me see if I've got it right now. No, not yet, not quite. Yeah, I'll take this off. Right, I hope everyone can see that. I'll just speak to it, and then we would have a role play. That would be nice. It would be nice to have someone who would act as the lawyer and someone who would be the client, the very angry client, taken from the scenario we've been looking at. So now what we're trying to do, it's been determined that the case is mediatable. So what we're going to be looking at now is how to sell the idea of mediation to our clients. Okay, so this conflict, as we've seen, has caused a lot of distress for the parties. Decisions taken in anger aren't always the best. So it's important that we acknowledge the emotions that our client is feeling, okay, at the moment. And the emotion could be one of anger, It could be one of disappointment. It could be one of anxiety, fear, and all of that. It's important that we normalize the feelings, the emotions that they have, because everybody seeing things from the perspective of our client is very likely to feel exactly the same way that our client is feeling at that time. And that should, normalizing it and being able to acknowledge it should help us calm that client down. And that being done, it's important, that we remain very objective in what we are doing. We've looked at the different things that have been said by all the speakers who came before me. Now, we need to clarify the client's goals, okay? What exactly is the client expecting to get from this mediation? What is his interest? What is his need, okay? And then we also need to consider, what does the other party want to get from the mediation? What will their needs be? Okay, and what would they be looking for? Okay, now we've looked at what the needs could be in this particular scenario. And if you ask me, for me, the most important seems to be the timely resolution of the issues, the timely conclusion of the contract, and to protect their reputation. For me, those are the things really to consider. And if these are the things, then these are things that are better done in mediation. Okay? It's not a matter that has to be decided in the court. So parties, with the help of a trained neutral, and the trained neutral will be one who, in neutral, let me talk about the neutral, is one who has no interest in the subject matter and is independent of the parties. Okay, and this neutral can then facilitate the conversation between the parties, discussing the issues in a way that both parties can listen to each other, appreciate each other's perspective, and both figure out how best to resolve the issues on mutually acceptable terms. Okay, now these will be terms that they can both live with. It is not exact, it may not be exactly what each person would want, but they can both accept to live by whatever it is that they have decided to settle with. No side would be forcing what they want on the other side, and the mediator would not be telling them what to do. Now, in business terms, what you would be looking at, the mediator is future focused. The mediation really is future focused. And the neutral will ensure that parties are focused on how to move forward and not on blaming and finding faults with one another. And that would enable both parties to continue with the contract without the discomfort of feeling angry and aggrieved. With the commitment of the parties, like Mrs. Adegbomire had said, mediation may conclude in one day or soon after, and parties can proceed with the contract very quickly. This means that the cost implication would be less than a prolonged dispute resolution. And people are normally anxious when they have to go to court or any other formal dispute resolution process. And in this particular matter, even with mediation, your party may be anxious as well. So it is an opportunity to be able to explain to your party, to your client, that the mediation provides a safe place for conversations. The mediator is not going to be trying the case and deciding who is right or wrong, but will listen to the parties, understand their perspectives, and help parties reframe and think outside the box and find creative, bespoke ways of solving their dispute. In so doing, the mediator also manages the process to prevent undue power play and provocation. The process is confidential, including the terms of settlement. Neither party nor the mediator can share the discussions at mediation with anybody outside of the process. What this means is that the dispute remains private and parties' reputation remains intact. The terms of settlement, when signed, become a binding contract between parties. And because they arrived at the decision themselves, there's the greater chance, the greater likelihood that they're going to adhere to the terms. You would also be available, you, the counsel, to help them review the agreement to ensure that it is adequately worded to protect their interests. In the event that parties are unable to settle their disputes, they are free to engage any other dispute resolution mechanism, and nothing shared during mediation can be used in any such process. Now, comparing it with a court process, litigation, for instance, this would be different if they were to go to the court. The strict application of law does not take the parties' interest into cognizance to the extent that mediation would do. For one thing, litigation is not confidential. Anybody can sit in the court process, including pressmen. The duration of the case is unpredictable, which would not be to the benefit of the parties, as they want this dispute resolved quickly so they can continue with the contract and deliver on time. Remember, they have a hospital to deliver. This would also cost more in terms of cost of dispute resolution and perhaps cost overrun in the contract. The judge will decide for you in litigation. You won't decide for yourself, and it's a winner takes all thing. The judgment would most probably cover who is right, who is wrong, payment of any outstanding damages and all of that, which will not sort out timely delivery of the hospital project and what works for future cooperation. A good relationship may be lost forever, including future prospects for a good team. So how do you recommend this confidently? You can only sell this recommendation if you believe in it. If you consider all the benefits to your client in terms of his business and not just your reputation for winning the case, you would be able, excuse me, to persuade your client to consider mediation. It does not reduce what you would earn, like we've heard, for the time you will put into the mediation, but will give you more time to pursue more cases and provide more workable options for your clients. Going to mediation does not mean your case is weak. It shows you understand what dispute resolution mechanisms will give your client what he needs. It does not mean you share 50-50. Understanding each party's perspective and the need for business continuity means you can find bespoke solutions acceptable to both parties. So these are the things to be considered when you want to advise. It's called the 5-step mediation advice framework. So now we would have a look at, I would stop sharing and we would have a look, we would do a role play. If I can have suggestions, people who would volunteer to be the lawyer and the client. So can I have someone who can act as the lawyer following these steps, and what the rest of us will be doing would be looking at whether they were able to sell mediation to the client confidently. So can we please have volunteers?
If you'd like to volunteer, kindly raise your hand and then you'll be unmuted. It seems no one is volunteering.
Exactly. There's no volunteer in the house.
Perhaps because there's no money involved. Maybe if the SLP chairman puts money on the table, there'll be volunteers.
Okay, we'll do that. So can we have 2 volunteers?
Someone's volunteering, Khadija Siddiq, volunteering to be lawyer.
Thank you.
Can you please raise your hand so you can be unmuted? I'm trying to look for you. Okay, yes, I see you. Unmute. Yes, I think you can now unmute, Khadija.
Okay, I'm
Yes.
unmuted.
Yes, yes, you are. And one more person. I don't see any other volunteer.
Nkechi.
Okay, Nkechi. I
Yeah.
think Nkechi now. Yes. Nkechi, please raise your hand so I can find you. I can't find Nkechi, but I've seen Martina Olarin there. Now we have more volunteers now. So permit me to just ask Martina to unmute. I couldn't find Nkechi. Martina, you've been unmuted? Yes. So we have two volunteers now. Yes. So moderator, you have the floor. Sorry. Facilitator, you have the floor.
So Moari is angry. Lawyer.
Yes. Khadija, you've been unmuted, please.
So, Mrs. Oyemene, I think you need to explain to them exactly what they are supposed to do. I mean, even to say, Khadija, you are the lawyer. Martina, you are the client. You've come to Khadija for advice on a particular dispute, and Khadija is supposed to go through the 5-step to advise you. Maybe you just explain to them so that.
Yeah, right. Thank you. Right. So, yeah, like Mrs. Arroyon said, Khadija, you're the lawyer. Martina, you're the client who has come to Khadija, sorry, and you're really angry. You don't want to hear about mediation. You want to go to court. You want to deal with your contractor, and you're not ready to listen to anything else. So, Khadija, you need to tell.
Sorry, they should understand that they're using the Delta build.
Yes, the Delta build, the same case we've been talking about. So, Khadija, you need to sell the idea of mediation to Martina. And yeah, what we will be looking at is how you're able to do that confidently. We're going to be looking at, basically that, how you're able to cover the 5-step scenario that we looked at, how you can talk to the party, consider the emotion, consider what the party wants from, what your client wants from the mediation, relate it with their business issues and not just dispute resolution, but how it affects them business-wise. Compare other dispute resolution mechanisms with mediation to sell to them why mediation might be better. That's what we will be looking at. So when you're done, we would look at what you did very well, what you could have done differently. Thank you. You've got the floor now. We have just a few minutes to do this.
Hello, good afternoon, everyone.
Yes, good afternoon.
Lawyer? Okay, good afternoon. Actually, I've not done this before, but I'll try.
You have the floor.
Also, please, I have issues with my partner. I gave him money and he promised me that the business is going to be a good one. And as it stands, all my stake are with him. I don't know how to get my things back, to get my money, to get the property. I go there today, it kept promising, and till date, I've not been able to get my money back. And the bank is running after me. Everyone that I've collected money from, it seems as if I've duped them, and I don't know what to do. And you are here telling me that you calm down. I can't calm down, please. Please. I need my money back, and he's not ready to give me. And I just don't know what to do. Please help me.
Please, we would appreciate the role players if you could just put on your videos so it looks like live, so that we can see you, we can see the emotions, we can see how you're feeling.
Yes,
please put on your
you
video.
can unmute yourself now. So I've heard from the client. Now we want the lawyer to address our client. Yes, you can speak now, Khadija, I believe.
Okay.
Yes, you have the floor.
Okay. Welcome once again, ma'am. Thank you for coming, and then I really I really understand the point you are coming from. And I would like to just quickly tell you that I understand that this is business. You need your money, you need your profit, and your integrity here is also very important. And I deeply understand what it means to need your money with immediate effects. And I wouldn't say that you are doing too much to want your money, actually, ma. We would definitely want to take up this matter so that we can protect your interest. And as we speak now, we have several options that are available for you to get your money. And exploring them is not a bad idea, but I would like to let you know that exploring to get your money and get your capital, get your resources, your profits can be very, very overwhelming and as much as the way you need your money now. However, we can actually table the options available for you. We can table the options available for you, and then you will take a look at it. But I am very, very much interested, as much as you are interested in getting your money back. So can I go ahead so that I can actually give you the options available for us to get your money back?
I appreciate the fact that, of course, you empathize with me, but the options you are going to give me now, how fast or how tenable is your option, please?
Okay, thank you so much again once, ma, for this. And the options available are, I'll just give you two options. I only give it two because I don't want it to be, because already I understand that you are stressed. So I don't want it to be overstressed as well. Yeah, so I'll just give you two options. To secure your money, we have litigation and we have mediation. I understand that you and your partner have been in business for a while. So let me just give you those two options.
You mentioned mediation. I know of litigation. Yes. Of course, you see yourself, that's when we do fight to fight anyhow. Yeah. But this mediation you are talking about, I hope it's not another way of, partying with my partner.
Okay, so I understand what you mean, because actually it looks new. So I won't overbeat this for you. I'll just tell you the way it is and explain the options for you. I'm very much aware that when you are informed now, you will definitely make the best decision. And I'm here to also help guide through it. So first of all, I know you already know about litigation, but let me quickly explain it to you briefly. Litigation definitely will go to court, but before going to court, I understand that you and your partner have been in business. You've been making profit, and I'm sure you don't want to make this the end of it. It might look like this is going to be the end.
With this, I won't try it again.
Okay. But you won't try it again, but business will definitely continue. If you're not trying it again with this man, you also have another business with another partner. Are you sure of that?
Of course. Okay. Yes.
So now, the point now is that if you want to go through litigation, have it in mind that as much as you are stressed now, you might actually need to go through a lot of stress for litigation.
But at least I'll get my money back. Yes.
I'm not guaranteeing you that. I as much trust myself. I know the extent of what the work I can put to table, but I won't be the one to decide for you. Okay. We are filing our matters. Right. We are going to appear in court, giving our appearance, argue, cross-examine, and examine. And at the long run, we are going to be putting our matter forward to the judge to determine for us. So I won't say that I have the final say. The judge is the alpha and omega of this court. However, I'm not saying the judge will be partial here. I will table my matter very well. The defense counsel will also will also, as much as I'm fighting for you, fight for his client. So we have that available now. That's the first option. It will cost you, madam. It will cost you. I mean, it will cost you in the sense that we'll fight appearances, we'll get adjournments. I'm not in charge of the adjourn dates. I cannot guarantee you when we will be in court and when we will not be in court. The registrar might say the judge is around today, he might not be around tomorrow. There might be holidays, there might be a lot of things that we will factor into it. But be rest assured that I will do your matter diligently with all my strength. And I can assure you that if there is law, and for us to be the last hope of man, we will definitely get something. We will get something, but I can't assure you of what we will get. That is litigation. Now, for mediation, for mediation, it might sound new, but it is not new. It is in the system, just that a lot of people don't know about it. So I would just like to tell you about it the way I've told you about litigation. For mediation, you and we would have your partner. I don't know how to start my video. Are you seeing me now?
No,
Sorry,
please,
you asked me to start my video. Are you seeing me now?
Go on. Your video is on. Your video is on. Go on.
Yeah.
Okay. So for the mediation, yeah, like I was saying, for mediation, we would want you to be on deck. We would have your partner come into the matter as well. In this mediation session, it's going to be like a session. You know what they call family meeting kind of thing? But it is not family meeting. It is where you would table your emotions all the time to talk about your pain. This your party, because in mediation, mediation will allow you to talk first. You will talk first, you will say everything you want to say without interruption. So you are talking, the mediator is listening. The mediator is a neutral mediator, so he's not going to judge you, neither will he judge your partner. So he will listen to you, and then there won't be interruption. After you've tabled your matter, the other party will also talk. Then the mediator will start asking questions. In the moment of this question, you will be saying where and how your money was, because it's going to be a confidential session. It's not going to be in the public. So the mediator will have told us that we have all the right to talk. Anything that is confidential, we can bring it out. So as you are talking, or as the mediator is asking questions, the other person will have been saying things you don't know, saying things that was not open to you. The mediator will be asking questions and will be leading the other party to a set to see where he has flopped, where his wrongs are, and where his rights are. Then he will facilitate between the two of you. You will be able to table what you want. Immediately the mediator asks you what you want, you'll be able to table it, and then the other party will answer. It will listen, because it's going to be an open ground where you will not be tense to answer questions. It might just be a session now, and then there might be a break. You come back for another session. So at the long run, each party will be seeing where the flop is. Each party will be seeing where their rights are and where their wrongs are. The law is there to guide, but there would not be a strict adherence to what you should do with respect to the law. So immediately the mediator is asking questions. There'll be some kind of understanding of how the contract went and how it should have been. So by the time the session finished, you'll have been able to table what you want now, and then the other party too. Because the other party might be angry. It might be telling you that everything you are asking for is too much, but the mediator will make the other party understand that he can negotiate. And I understand that you might be thinking how will they be negotiating your money? But if you explore this mediation, you will see that even if it's negotiating, you're not going to lose everything, and you will win. You will win, but you might not win everything, but you definitely win.
I think I have to jump in now and hand over. Thank you very much, Mama. I think I have to jump in and hand over to the facilitator. I think both the lawyer and the client got the brief of the assignment, and I just ask the facilitator to just take it from there. Yes, please.
All right, thank you.
Okay, so I think that she handled it confidently. I like the fact that she took her client through the process, how it's going to be when they get there, what's going to happen. I like the fact that she talked about the time and that it would take, which is very critical in this particular case. They've got a project to deliver on, so it's important that they are able to settle all of this very quickly and proceed with the project. So those are the things that I think we need to know. Figure out how to make it, how to get the client to understand that it would be to their benefit to use mediation. Thank you.
Thank you very, very much, Mrs. Oyeminem, and thank you most importantly to our two volunteers, Khadija and Martina, for agreeing to take part in this role play. I'm sure that the SLP chair is listening, and she will do right.
Yeah, we'll be sending both of them the SLP journal for the past 7 years each.
Wow, thank you very much.
Thank you both of you for
Thank you very much, Madam Chair. We're very, very grateful. So now that we've learned the how to advise our clients to choose mediation, we then need to conclude this session by looking at ethics and professional duties. Ethics and professional duties as it relates to mediation. There'll be two people that will speak about this, Mrs. Olushola Adegbomire, and I'm also going to have Ms. Dr. Adeyemi Agbelusi. Now, Mrs. Adegbomire would speak on duty to advise on ADR and then confidentiality limits, whilst Dr. Agbelusi would address authority to settle and avoiding coercion. You both have 10 minutes each. I'd like to call on Mrs. Olushola Adegbomire first. Duty to settle, duty to advise on ADR and confidentiality limits. Mrs. Adegbomire, you have 10 minutes, ma. Can admin unmute Mrs. Adegbomire? Can't find her.
Thank you.
Okay, yes.
Okay,
you have the floor.
So we'll talk about two things. The first one, I'm not going to spend too much time on it. The reason is because Mrs. Doyin Rhodes-Viver spoke about it in detail, even giving the rules in the sections in the different rules. I'm just going to say that most of the rules of courts make it more or less mandatory that we must advise our clients to try to resolve amicably before going to court. In fact, in Lagos, you need to show that you have tried to settle before you can come to court. You must have something proven. Oftentimes, maybe you've gone to mediation or something to show to the court that you have tried to resolve before you go to court. And it's not only in Nigeria, it is becoming global that there's that encouragement that you must have tried mediation. Mandatory mediation is even becoming a usual thing in many parts of the world. In the UK, in many places, you are expected to do mandatory mediation. In fact, in some places, including in Lagos, I can talk about Lagos because that's where I know. If you do not try mediation, or you go to mediation and you are not cooperative, you can be penalized in costs. So oftentimes when you do a mediation, even in multi-door court, you are expected to do a report where the parties don't settle. You're expected to do a report back to the court, and then the court determines what to do about it. That shows us how important and how much the court considers the duty to advise on ADR. I'm happy to see that more and more lawyers are becoming ADR compliant. They are becoming supportive to ADR. I've sat as a mediator in cases where, in fact, one I will never forget, when I started the matter, when I got to a particular place, the lawyer actually said to me, "Madam, keep quiet, me, the mediator." And I just kept quiet and I changed my strategy as the mediator. They were there because they didn't have a choice. The lawyer did everything to stop them from coming to that mediation. But I was so glad when at some point in that mediation of asking questions, and I always say you have to ask the right questions. We got to a point where it was his own client who said, "Lawyer, keep quiet, let us hear what this woman is saying." And so and I believe that's why the law says we must advise our clients to try ADR, not discourage them. And there's a cost for lawyers who do not. Lawyers who make, because maybe the lawyers don't know that the mediator writes a report, especially when parties don't settle. the mediator has to write a report, you know. The things that go on are confidential. It's the lawyer, the mediator is not going to say A said this, B said this, but the lawyer, the mediator is going to write a report to the courts. So that is one about how important it is and what the law has to say about lawyers encouraging their parties to settle in court. That's the duty to advise on AGR. Now, secondly, confidentiality limits. I think we need to understand confidentiality for me is one of the bedrock principles in mediation. But of course, it has limits. However, confidentiality in arbitration is in about two levels. One, when we have the joint meeting, and I think we've heard about the process of mediation, the joint meeting is confidential. Then the private meetings, we've talked about private meetings. The private meetings are also confidential. Of course, confidential means anything we say cannot be discussed outside. In the general meeting, whatever we say in the general meeting, none of us can use it outside of the general meeting. When we go into private meetings, if I'm in a private meeting with A, whatever I discuss with A, if A does not want me to tell B, I cannot tell B. Whatever I discuss with B, if B does not want me to tell A, I cannot tell, except I just convince them as to why. However, there are limits to confidentiality. What are these limits? For example, when it comes to matters of crime, you cannot keep it confidential. If a person is telling you, I intend to go and commit murder, or I committed murder, you become an accessory. So there are limits to confidentiality. What we've done, at least what LMDC always encourages, is that if you meet such things in mediation, and it's like that with many institutions, if you meet such things, you are supposed to report to the institution. They've had a case in LMDC where a party was saying, I have HIV, or some ridiculous, something like that, and I don't want my partner to know. The person had to report. As much as there's confidentiality, there are things that you cannot keep confidential. When it comes to crime, when it comes to things that will affect another person so deeply like HIV, you are supposed to report to the institution. Now, where there is no institution, I believe there are some things that you may have to report to an authority or to the police so that you do not become culpable in a crime. So as much as there's confidentiality, and it is confidentiality that makes people keep talking, you have to, there are limits to that confidentiality. There are things that if you hear it, you are not allowed to keep quiet. Things that tend to crime, things that tend to health, things that tend to life and death, you are not allowed to keep quiet about it. And that's the beauty of mediation as well, that, I mean, even though there's confidentiality, is the bedrock of mediation, it does not mean that mediation allows people to hide things that they cannot hide. Of course, mediation too does not allow people to hide such things. So there are some people who actually put mediation clauses in their business. There's some businesses that go to arbitration. They have an arbitration clause simply because they know that what they are doing is not enabled by the law. So they put an arbitration clause. People doing mercenary contracts, people transacting in sale of people, slave trade, things which still go on today, but which are so illegal. Then they put an arbitration clause or a mediation clause so that what they are doing is not going to get out into the general public. Mediation is not to hide criminality and evil. And so that is where confidentiality is limited. As much as you can say anything, and the beauty of mediation is you can say anything and you know that you can get away with saying it. But that is the limit of confidentiality when it comes to criminality, especially, and things that affect life and death. That there is that limit to what you can talk about. And I will stop here. And I want to know if anybody has any questions on those limits of confidentiality.
We'll come back to the questions shortly. And thank you very much, Ma, for setting the limits on confidentiality and also taking us through the respective rules as relates to encouraging ADR prior to going to court. Dr. Agbelusi, please tell us, authority to settle and avoiding coercion. How does this play out in mediation? Thank you, sir.
Fantastic. Thank you very much. And once again, I want to greet the distinguished colleagues, and I've seen some members of the bench and bar in the room. Thank you once again, Madam Ali, for the invitation. So authority and coercion are at the heart of ethical mediation practice. While authority deals with the truthfulness in terms of representation, the other is about freedom in the decision-making process. So if either of these are compromised, you will find that the process of mediation loses its legitimacy. And in the long run, that's even more costly than a failed mediation. So when you talk of authority to settle, you know that good counsel practice should definitely have honesty, candor, and be factual in their representation to the other party. So even though it's a negotiation, and of course there's the psychological and strategic tactics that a counsel and a party will bring to the negotiation table. But the counsel has a duty under the rules of professional conduct to conduct his case with honesty and with a proper representation of the facts within the disputes. So before the session ends, in preparing the mediation brief, the counsel must clarify authority from the client. Is it authority to represent or authority to represent and bind? I found that many counsel come into the room without this clarity. So it may be ethical to say, look, I need to consult my client to know if he will accept this. Or the counsel himself saying, my client cannot take anything less than this. Whereas when the client walks into the room, he may take it. So I've been in several mediations where the parties have walked out their clients because they became a cog in the wheel of settlement. So a client who is going to a mediation is not going as an advocate, he's going as a mediation advisor. And it is always best that he clarifies the strategy as to what will be my role in the room. Because in mediation, the party autonomy and the consent of the parties is what actually drives the process. So the counsel in the room becomes a supporter, an advisor to the clients. So there's no need for the counsel to make absolute statements. We will not take this, we are working out, if these are not true. Because what you're doing is that you're not allowing the counsel, the client, to be at the center of decision making. And that's very, very key. So moving from authority to settle to coercion. Coercion can take different forms. It could be lawyer to client, where the lawyer is forcing the client to settle, saying that you have a very bad case, just accept the money. Or it could be party to party, whereby the parties are using the leverage, that maybe they're the Goliath in the room to harass or to intimidate the David, take a settlement. Or it could even be systemic, where the mediator is pressuring either party or both parties to settle by saying, oh, if you go back to court, you'll be there for 10 years, you'll be there for 5 years, judgment will not be favorable, etc. So again, this is an ethical responsibility that lies both on the client and lies on the party, but I think also lies on counsel, because the rules of professional conduct guides the counsel. Of course, the legal profession is one of the most regulated professions. So the counsel in the room should be able to help his party take the right decisions take decisions voluntarily, and also take decisions without intimidation. And once a party willingly takes a voluntary, informed, and unpressured decision without prejudice and signs the agreement, then the problem of later challenges, the problem of non-compliance, the problem of enforcement, or a breakdown of the agreement, of course, comes into the room. In my own practice, I remember I've seen matrimonial causes where the lawyers are even more aggressive than the parties who are in contention themselves. And of course, these are things that are not best practice and are not ethical. So coercion of parties, yes, we need pressure in the room. We need scare tactics. We need people bluffing because we're negotiating. But the council has a duty to make the room as sanitized as possible, so that our negotiation is not just scaremongering, and people are not just intimidated to take a settlement. At the end of the day, they are unable to perform, and then we're back in court again for enforcement. So those are my own thoughts on those two issues.
Thank you very much, sir. You've spoken very, very well. To ascertain whether our members are following, I'd just like to pose a few questions, and I'd like to read the answers in the chat group. What would you do where your client refuses mediation out of anger? What would you do? Number two, please, we would like to read the answers in the chat room. Mediation. What if your client wants to withhold key facts during the mediation? I would ask those questions again, and we'd like to read the responses of everybody who's here. What would you do where your client refuses mediation out of anger? What would you do where opposing counsel delays the matter through mediation? And what happens in a case where your client wants to withhold key facts during mediation? We'd like to read those answers, and based on the answers in the chat, we'll then ask our faculty to address what our people would have said. So I'm going to the chat now to see what I can find there in terms of answers. Georgina says, I will calm my client down and appeal for understanding. Emmanuel says, you give the client time to be calm and reconsider. Timotokpe says, where there is anger, let emotions cool down first. Ineka says, I will re-strategize first and find ways to bring it back to their goals. Forgive me, the chat has jumped again. Very, very nice answers are in the chat room. Adenka says, I will inform the client of the benefits of mediation. So, Mr. Dr. Agbelusi, from the answers participants have given, and please, Mrs. Adegbometu can please feel free to chime in at any point in time. What would you like to say? I'd like to please distinguish between strategy and misconduct, where I decide to frustrate mediation as my strategy. Does that amount to misconduct? What if I decide not to give an information? Again, how does that play out in the context of mediation? We would like to have your response, and Mrs. Adegbomire too, would like to have your response to this too.
Okay, so where a party or a council misleads the mediator or the other party, and it underlines the credibility of the session, potentially counsel is allowing himself to be in breach of the rules of professional conduct. So there's a difference between holding back facts until the right time or lying and actually making a misrepresentation. So it's a very thin line and it's a gray area, and that's why I think that the rules of professional conduct even have a stronger role in mediation and even in litigation, because we are here in good faith. We're here voluntarily. We're here with consent. and we are here to compromise our case. So if for instance, in the second position, you want to delay tactics, it is best to take the mediator into confidence. That's where confidentiality comes in. I say, look, my client doesn't have money to pay now. He needs 4 months so that his finances, they can give a payment proposal. So can we adjourn for 4 months, or can you call the party to give us more time to bring a proposal rather than propose now under coercion and then fail? Or will he accept that we sign an agreement now, but the first tranche of payment will be in 4 months' time? These are the kind of facts that counsel should do. So I think the real thing is really knowing what cap you are putting on. As a professional litigator or a trained lawyer, yes, your aim is to advocate your party's position. But in mediation, it is not A versus B. It is A and B versus the issue. So it's a collaborative process. It's not adversarial. Once you have that in context, then a party being angry or trying to delay, we're all together, we're all one big family. And that's why everything we do is without prejudice, and all legal rights are suspended while you're in mediation. So you can explore a solution. And if it works, so be it. If it doesn't work, so be it. So a party that is angry coming to mediation, yes, mediation is where you ventilate. I mean, I had a matter last week where the two parties had about 3 lawyers on each side. And by the time we came to a settlement, when we agreed on the final sum, the party wept. It wept bitterly. It was a foreigner. Now, why was it crying? It was crying because even though it was settling, it still felt that, look, I'm doing this because I don't have a choice. His dog was dead and was paying for almost $200,000. And at the end of the day, he just felt, look, this is a painful pill to swallow. But mediation is win some, lose some. It's not a win-win situation. So it's really about clients, counsel, attending trainings, equipping themselves by mediation. It is a core skill that once you know, you come into that place and you join the mediator as a co-mediator to resolve the disputes. And if it fails, you put on your wig and gown and you go and battle it out in the court. You know,
okay. Mrs. Adegomire, your thoughts on those posers and the answers that participants have given in the chat?
I just wanted to add briefly that is one of the reasons why mediator and counsel have to work together. Whenever I sit as mediator, one of the things, even in my opening statement, I always let parties and counsel know that at some point I will have private meetings with parties, but that I will also have private meetings with counsel, because you have to let counsel know that they are also very, very important in the process. I believe one of the reasons, amongst others, why some counsel just make things difficult is that they feel that you've relegated them to second position. You know, sometimes you hear things like, oh, the parties are the important people. The parties are not the only important people in mediation where they have lawyers. The lawyers can make or break as well. So I let the lawyers know that, look, you have a very important position, and I'm going to have meetings with you personally. So just like Dr. Bolu said, the lawyer then knows he has the forum to meet with me and to tell me why he's not even encouraging his client privately. And so it is something that we all have to work together. Counsel must always know that they have the ear of the mediator. Counsel must know that the mediator has their best interest at heart. It is not ADR, alarming drop in revenue. Counsel does not want them to lose money. I mean, the mediator does not want them to lose money because they've come into mediation. Oftentimes, I make it very clear the role of counsel in my mediation. I make it very clear that, oh, counsel is going to do this, counsel is going to do this, counsel is going to... So right from the beginning, you're not thinking of how you're going to get out of not paying your lawyer in any mediation. Lawyers and mediators, if we work together, we can get a lot done and everybody will be happy. The client will be happy, the lawyer will be happy, and the mediator will be happy for them. So that's I think we have to, I want all the lawyers on this platform to know that we are working together, mediator and counsel. Please.
Thank you very much.
And please, I'm so happy for this program. I thank Mrs. Ali a lot, because this can be a real game changer in practice, not only in Lagos, but in Nigeria. If we can get to the point where mediation becomes a really big thing, bigger than litigation, bigger than arbitration. It's going to be a game changer in law practice if people really begin to understand the role of lawyers, of counsel in mediation. So really thank Mrs. Ali and Mrs. Aroyehu. I see a new beginning in law practice in Nigeria. It might just look like just like a webinar. I don't think so. I see more than that in this program we're having. Thank you very much. And thank you, our moderator too.
Thank you, Mrs. Adegbomire. I think that it was what I said earlier. The stakeholders are listening, and I know that many good things will come out of what we are doing this afternoon. We'll come to the Q&A shortly, and so if you have questions, please ask that you type them in the chat box so that our faculty would address them. I see I have Mr. Kenda NOSN, Mrs. Adedoyin Revival, Mr. David Ogebe, Mrs. Chineye Onyemenam in the room. So please, if you have questions, please type your questions in the chat box. We'll take them. But my key learning really from what we've just discussed now is for us as lawyers to be ethically disciplined, and that ethical discipline strengthens credibility and enforceability. Mediation is win-win, and even we as lawyers, we can still make our money through mediation, and not necessarily thinking that we must go the whole hog of litigation for us to make our money. So the point is noted and everybody is listening. So we are now getting into the Q&A session. I saw some questions earlier on. I would read them out, but if you have new questions, please put them in the group. Now, there's a question from Jude. It says, please, may I know how a non-cooperative person to mediation can be penalized by the courts in Lagos? I think I can answer that. There will be a mediation report where, the party that frustrates the mediation, the court has the powers to award costs against such party in the judgment ultimately. So that is contained in the rules of court. So I won't leave that. I think even though I'm not a certified mediator, I think I can answer that question. There's also another question from, forgive me now, I picked that question earlier on. And there was a question for the panelists to distinguish between arbitration and mediation. I'll just really throw that to Mr. Adegbomire, and they asked for you to distinguish between arbitration and mediation. Please, can you just quickly do that, and then we'll go to the next question.
Distinguish between arbitration and mediation. Oh, that's very easy. Arbitration is a dispute resolution process where the person in the middle, who is called an arbitrator, makes a decision. That is the key difference. He makes a decision for the parties. That's called an award. It's similar to a judge making a decision. In mediation, the mediator is only helping the parties. And I'm now reducing it to the simplest method. The mediator is only trying to help parties to settle. He's a negotiator. He's helping them to negotiate and to come to terms of settlement between the two of them. He's not making any decision for them. He's not saying you are right, you are wrong. The arbitrator, on the other hand, makes a binding decision, an enforceable binding decision. The mediator helps to settle. However, if the mediator can help them reach terms of settlement, which they sign, then their terms of settlement, which they have reached by themselves with the help of the mediator, becomes binding as well. That's all.
Okay.
One makes a binding decision.
Thank you very much. There's a comment from Ruben. It says, please throw light or guidance on this. A reputable lawyer is approached or engaged by a litigant but does not have the money to pay his bills. He advises the litigant that he will use his own resources and use the case for him and thereafter share the proceeds 50-50 with the litigant. How does this affect mediation? Can any of our learning six address this? Where your fee is tied to recovery and you most often think that you can only get recovery from litigation. Any of our learning six, please, I'd like you to just address this question from Ruben. Okay, I'm not sure maybe they're trying to unmute themselves, but Dr. Adbelusi, do you want to have a shot at that?
Maybe you should. Okay, I was thinking you should just call their names.
Yes.
Well, yes. Let me give it a shot. I can give it a shot if you don't mind.
Yes, please. Yes, Mr.
I I think the first thing to try to resolve or try to be very much aware of is to settle or agree on the issue of your fees ahead of any mediation session. Because there is a tendency for clients not to see the basis of the kind of fees you might ask for. If the matter is settled, it may be in a day or in 3 days or in 4 days or in 5 days. So you've got to find a way to ensure there's a definitive contract in terms of your mandate and your fees, because you don't want another litigation on account of your fees, which is not unlikely and is not unusual. Now, to the point as it relates to whether your fee can be tied to success of the case itself, I think it's important to review the nature of the case appropriately and be clear that it is one that is got the likelihood of some measure of success and is not unusual for you to engage on that kind of arrangement. I think a 50-50 might be a bit of a steep, but whatever it is, just ensure you agree or review the nature of the case, and then you can then agree. You may be in a much more favorable position, to be honest with you, if indeed it is on a contingency basis, but it is usually few and far between, but it's not unlikely. The banks do it, which might be on the basis of a recovery, but is also applicable in other instances as well. So you can surely find a way to make that happen, and that can be. But please ensure there is a definitive agreement on the nature of your fees and also how much you're going to earn. So it's result oriented, is not in any way based on how many years you have been on the case itself. Those would be my thoughts on that. Thank you.
Thank you, Leonard Silk. Dr. Agbelusi, do you have any comments or thoughts on
I
that?
perfectly align with him. And
okay. There's a question, and this should be open to Mrs. Adegbamire. It says, when parties agree to settle, is it proper for the mediator to draft the settlement agreement? Though this person acknowledges that sometimes they take input from counsel. Who should draft the settlement agreement when you're at the LMDC? Mrs. Adegbamire, for you, ma'am.
Well, usually, I always encourage counsel to draft it. First of all, it's part of the work counsel is being paid for. Those are the things that make a party feel, oh, my lawyer hasn't done anything. The mediator was the one who resolved. The mediator was the one who drafted the agreement. So what am I paying for? So I always encourage, and counsel has a better view of the whole matter. Counsel has sat through the mediation. Counsel understands what his client has agreed to and has not agreed to. So usually I allow parties and their counsel to draft, and then I review it. Now, sometimes you may have situations, and there are many, where there's even no counsel. Where there's no counsel, I can draft as the mediator, but usually I prefer for counsel to draft their own counsel.
Okay, thank you. I'll take the very last question from the chat group. This is from Larry. He says, how do you determine your fee as mediator? Anybody can answer this question? How do you determine your fee as mediator? I know there's a scale of fees, but I'll allow Mrs. Adegbamire to answer that question.
okay.
I don't know why Mrs. Adegbamire is answering this one, but yes, you are right. There are many scales of fees, so it's to take one. I usually take one, and I use that one. If they want my own scale, I'm happy to send my scale of fees. But the point is, one thing, you either determine your fees per hour or you determine your fees on the quantum. That's the first thing, So, and then what you now determine to be your fees per hour and what you determine to be your fees on quantum would be based on the different scales of fees. And of course, you can also determine your fees based on the currency of the disputes. I see some people smiling, but basically it could be per hour or it could be on the quantum. Some are just short and straight to the point, and the quantum might be a lot, but it might be a simple mediation. So we must not make it all about money. And so sometimes in such a case, you can use the number of hours you spend. You may not spend too much time. But that does not mean that it's not a huge amount, but it's not all about, or want to just take all their money. So, because that way you want them to keep coming back. Let the council charge, or is it the charges of the council they're asking about?
No, I don't think it's
I think
council's
it's the charges of the mediator. Yes.
Thank you very much. At this point, I'd like to take the closing remarks from every faculty member. Thereafter, I'll call on Mr. Isaiah Buzimo, the chairman of the AGR subcommittee, to close. So closing remarks from our faculty members in no particular order. Closing remarks from
I
our
just
faculty
want
members.
to repeat what I've said, to thank Mrs. Ali, Mrs. Aroyewo, and Mr. Isaiah Bozimo, Mrs. Ali and Isaiah Bozimo is here, and to ask them to please let us see how we may eventually end up with a pledge. You know, we have an ERA pledge for a women in arbitration thing, where people are signing up to it. It would be wonderful, especially starting with the big companies. Perhaps the MBA SLP might be able to go a step further and set up a mediation first pledge with the big companies. They sign up to a pledge that says, if we have a dispute, even if it's just between the big companies, if we have a dispute, the first thing we will do is mediate. It can come in the telecoms companies, the oil and gas, telcos, oil and gas, construction, those big areas. I hope that they are able to go a step beyond. All the lawyers have heard what needs to be done now. So if they can go a step further and set up a mediate first pledge that we can all begin to sign up to, it will be wonderful. And eventually lawyers too should sign up to it. Thank you.
Thank you very much. Let me call on Mrs. Doyin Rosevival. Your last words, ma'am, on this webinar. Mrs. Rosevival.
Hello, can you hear me?
Yes, we can.
Can you hear me?
Yes, we can. Yes.
Thank you very much. Sorry, I've been going in and out of the room because I had to also attend to certain things, as I had explained before. Let me first of all start from the comments of Mr. Kende, I know SAN, when I gave my views that it's not compulsory that everybody has to be SAN, and therefore be looking for cases by all means. And I gave my own experience, and he had another view that he doesn't agree. Well, first of all, I think all of us have to appreciate that everybody has their own career line in life. I didn't choose to become a SAN because I was looking for money, or I thought I just had to be. It was my career path that led me to that. And I want to start off by saying that in the first place, I started in the Ministry of Justice, and I was an advocate. I think the important thing is for due recognition to be given to every one of us, whether we are SANs, or we are mediators, or we are arbitrators. In England, some people who are, can you hear me? Hello?
Yes, please. Yes, we can hear you. Go on, please.
Yeah, I think proper respect has to be given to all of us, irrespective of whether we are SANs, we are arbitrators, or we are mediators. In England, where we have quite a large number of cases, other members of the legal profession who are not cases are also accorded respect. And I'll give one example. If you, as far as I know, if you work in chambers and you're a SAN or you're a King's Counsel, the fact that you're a King's Counsel does not mean that the name of somebody else who is your senior and has always been your senior in that chambers should be superseded just for the mere fact that you're a SAN. The privileges of SAN is clear in the act that set it up. The right to be granted audience to call your case first. Nigeria is one of the very few jurisdictions that you find that when people are SANs, they want to try and overreach other members of the bar. At any given time, they want to show they are the senior. When they are drafting an agreement that has nothing to do with appearance in court, they want to put their names before somebody who is much more their senior, who has more experience than them in that particular field, just because they're SAN. I think we should be looking at areas like that to discourage the practice whereby people think they have to be SAN by all means and at whatever cost, including the cost of not complying with their professional obligation of honesty and integrity. Because when you go and manufacture all kinds of cases, or you go and appeal a case that you don't have to appeal, because you want to get sand, it also shows some poor element of character. That's sincerely my view. And I think everybody in the legal profession, the professionals, every one of them, the people in the universities who are a very, very important part of our lives, should be accorded their due respect. You've even seen that in the guidelines, they've reduced the number of academicians that can be made sand because they said it's for advocates. But that doesn't stop everybody else being respected. Professors are very crucial. Arbitrators are crucial. Mediators are crucial. Advocates, you are accorded sand, but that does not mean we should lord it over other members of the legal profession and create this situation that we have now.
Thank you very much, Leonard Silk. Thank you very much, Leonard Silk. Points duly noted. Let me invite Leonard Silk Kenda Eno for his closing remarks.
All right. 3 quick thoughts. Number one, I think as a body, this particular committee or this section of the Nigerian Bar Association should make it a priority to engage with the LPPC, the Legal Practitioner Privileges Committee, in order to find a push and advocate for a way that mediation in of itself can be accommodated as part of the criteria in terms of making silk. For example, 20 cases that are required from the trial court should be in a way where at least some of those cases should include matters that are resolved via mediation. That would help this entire process, of course, a great deal. And I think it's important for us to come to terms with the reality of where we are and what we need to do. And I think we should address this from the underbelly. And I'll encourage the chair of this committee, my very dear friend and learned brother Silk, Chief Folashade Ali, and of course, without a doubt, my very dear sister, Mrs. Doyin Rose-Vival, SAN, to also join that crusade to see that something meaningful can be done. It is a project that I am passionate about, and I think it's something we should try to do. If they reduce the number of appellate cases of the Court of Appeal to about 4, and then the remaining 5th one can then be something that is done under mediation, it will go a long way in terms of decongesting our court and making people to embrace the mediation as a whole. And I think it's important. So that engagement is number 1 in my view. The second engagement is engagement with the Council of Legal Education in such a way that the training on mediation should, as of necessity, be part and parcel of the curriculum in the law school and also in the universities, so that people are taught early, not just about how to file statement of claim or statement of defense, but precisely the place of mediation, the place of arbitration, and more importantly, negotiation in the grand scheme of things. I think it's an engagement that this particular section of the NBA should lead. That's number 2. Number 3, and finally, is that it would be good to sustain this particular initiative. I think it's a wonderful initiative and it's a step in the right direction, but I hope that it can be sustained and they can find a way to escalate it into a much more entrenched part and parcel of the section itself. Thank you very much. It's been a pleasure indeed. Have a wonderful day.
Thank you, Leonard Silk and Mr. Kenda Eno. Let me invite Leonard Silk, Mr. David Ogebe. Your last words, please. Yes, you can speak now. I've unmuted you. You need to unmute now, forgive me. I've given you access. Yes.
Okay, thank you very much. Yes, I'd like to thank the chairman of the SLP and the chairman of this committee for having me. Just 2 comments. First, I started practice, and at the point of when we started practice, emphasis was always placed on how to defeat the case of the opponent, more like preliminary objections. But with time, fortunately, I've started seeing the sense in trying to get commercial results and getting solutions. So I would encourage all our colleagues not to have that mindset of just winning in litigation. You can win in litigation and get absolutely nothing out of it. And so let's all try to remove ourselves emotionally from the matters, try to be as dispassionate as possible, and find solutions for the client. Secondly, I'd like to completely agree with Mrs. Rhodes Vivo SAN. Let's not just file cases for the sake of becoming an SAN. If you're just filing cases and appeals because you want to become an SAN, that already is a misconduct issue. Build your practice. There will always be cases that must go through litigation, one way or the other. I ran my practice for 17 years before I was able to complete my matters and become an SAN. That doesn't mean you should just, so where are you rushing to? So allow the practice to grow organically, and then you can apply when it's right. Thank you, and I wish you all the best. Thank you.
Thank you very much, Leonard Silk. Mrs. Chinyere Onyemenam, your parting words.
Yeah, I want to thank the chairman of the section for inviting me, and then I would like to recommend to all the lawyers who are yet to be trained as mediators to go for the training. And not only will it help you advise your client, it would give you much more that you can do to help them resolve their issues, even yourself in-house. And it's so fulfilling because you can come up with bespoke solutions to what your clients need. It broadens your mind on what can be done. So that's what I'd like to say.
Thank you very much. Dr. Agbelusi, your parting words before I invite the subcommittee chair.
All right, thank you very much once again. I want to thank Madam Flashade Ali, SAN, and the section for the invitation. Two things I would like to leave. One, I think mediation is the queen of dispute resolution, and it's not only what you achieve, but how you achieve it. And so I will echo the voice of everyone who has spoken here, that is something that we should all look at. Commercial matters really have no place in court. So to the extent to which a counsel can keep it out of court, please make every effort to do so. Secondly, I will quote the words of a lawyer at an MBA conference in Ado-Ekiti a few years ago, that lawyers are transaction engineers. And where transactions break down, they should, like an engineer, think out of the box to see how they can resolve it. And I think I'll just end there. Thank you very much.
Thank you very much. I have the honor of inviting the chairman of the Arbitration and Ideal Committee of the NBSLP, Mr. Isaiah Bozimo, for his closing remarks. Leonard Silk, you have the floor, sir.
Bisi, thank you so much. And let me first add my thanks to each of the speakers, learned senior advocates from Nigeria, very esteemed practitioners in arbitration and ADR, in mediation in particular. I thank you so much for sharing your views. And if I can borrow from the words of Dr. Agbelusi, you engineered this session extremely well. And I would also like to thank Bisi for doing a fantastic job in moderating this session. I expected no less, and you really did a wonderful, wonderful job. Thank you also to everybody who has attended. We had up to 580 at one point, and we still have close to 400 on the call, which tells me that this conversation was very engaging for you. And if it was, I would encourage you to join the MBA SLP. We have sessions like this all the time. This was only part one of a mediation first session. Going forward, there will be a second edition where we will discuss in very great depth the advocacy skills you need to conduct mediation right from the opening sessions to the settlement phase. Likewise, we have sessions on arbitration. We had one a few weeks ago where we discussed the opening phase of an arbitration. And again, we'll be moving forward to discuss the preliminary meetings, the hearing phases, the advocacy phases. And we're doing this because we want to equip Nigerian lawyers to be 21st century ready, to be ADR ready, to be ready irrespective of the situation that confronts you or your client's interests. So that is my plea for you to join the MBA SLP. And more importantly as well, all the resources that we're sharing on these programs will be on the SLP's portal. So the playbook that will come out of this session will be on the portal that is accessible by members. The playbook we devised for the arbitration session that came before this is also on the portal. So please, please, please engage with us. Let's continue to have these conversations. One thing I want to mention before I hand back over to Bisi was this is not only an educational conversation. This is also a policy changing conversation. And I take to heart the words that were mentioned by Mrs. Adegbomire, my chair, for suggesting a mediation first pledge. My chair, I suspect that we won't have a problem in getting the big companies to subscribe to this. I suspect who we might need to engage are the smaller companies who, from my experience anyway, seem to be more litigious than the bigger, more commercially minded companies. So, and likewise, Mr. Kennedy, I love the suggestion, Mr. Aino, of engaging with the LPPC. Incidentally, the LPPC is conducting an engagement at the moment with a view to revising the guidelines for conferment of the rank of Senior Advocate of Nigeria. And I can say that, of course, with the permission of the section chair, we will make an engagement and make a submission to the LPPC along the lines of what you have suggested. And we will be sustaining this initiative. Like I said, this is only part one in conversation for mediation, as it will be for all the other ADR sessions. So continue to engage with us. We want to hear from you, and we want to hear how together we can build solutions that will benefit us as practitioners in the practice of law in Nigeria. So thank you very much once again. I wish you a happy Workers' Day for tomorrow, a very nice long weekend, and hopefully see you soon in one of our future events. Thank you, and God bless you.
Thank you, Mr. Bozumo.
Thank you, Chair. It's been my pleasure moderating this session. My name is Olabisi Makonjola. I've learned a lot from this, and watch out for the NBSLP. There's a lot more coming from this direction. Thank you, everyone. Happy holidays. Good night and goodbye.